Hello, my name is Michael Larch. I'm an attorney and the Elder Law Unit Head for South Carolina Legal Services. South Carolina Legal Services is a statewide nonprofit law firm providing civil legal services to low-income residents throughout South Carolina. My practice primarily focuses on issues affecting seniors and adults with disabilities. And today I'm here to talk to you about properly vetting a guardianship case. And hopefully by the end of this video, you'll have a good understanding of what less restrictive alternatives are out there and only file guardianship when it's absolutely necessary as a last resort. Now, the general rule is that when people turn 18, they have the authority to manage their lives, handle their financial decisions, make their own medical decisions, live where they want. But when a person's condition renders them incapacitated, a guardian might need to be appointed to handle affairs for them. So generally speaking, incapacity is an individual age 18 or over who lacks sufficient understanding or capacity to make or communicate responsible decisions concerning himself or his property. Now, effective January 1st, 2019, the South Carolina Probate Code, Article 5, defines incapacity as the inability to effectively receive, evaluate, and respond to information or make or communicate important decisions such that a person, even with appropriate, reasonably available support and assistance, cannot meet the essential requirements for his physical health, safety, or self-care, necessitating the need for a guardian, or manage his property or financial affairs, or provide for his support or the support of his legal dependents, necessitating the need for a protective order. That's the statutory definition that will be in effect. But what we're really doing here today is we're going to consider the alternatives. So as an attorney or a concerned family member considering a guardianship action, you need to investigate and attempt less restrictive alternatives before you file any kind of legal action. And there are statutory requirements compelling consideration of these less restrictive alternatives. As of January 1st, 2019, the revised Article 5 of the Probate Code has these requirements in effect. First, Section 304A requires the court to exercise its authority to encourage maximum self-reliance and independence of the alleged incapacitated individual and issue orders only to the extent necessitated by the incapacity. Additionally, the person filing for guardianship, that would be the petitioner, must show the reasons why guardianship is necessary, including why less restrictive alternatives are not available and appropriate, and a brief description of the nature and extent of the alleged incapacity. The guardian ad litem, who is an individual appointed by the court to advocate for the best interests of the alleged incapacitated individual, essentially the eyes and ears of the court, is required to investigate less restrictive alternatives and to discern the wishes of that individual. And finally, the court may only appoint a guardian if clear and convincing evidence shows the individual is incapacitated. This is important. You're taking away somebody's rights, their liberties, and in many ways it's more prohibitive than even a criminal conviction. So in our case study today, we're dealing with a client named Jane, and she's come to us concerned about her mother, Mary. Mary's 78 years old, and she's been diagnosed with dementia about 2 years ago. Her husband died 3 years ago. Mary has 4 children, Jane, 2 sisters, and a brother. And our client lives in town with her brother. Now, our client reports Mary's car recently was parked in the driveway with side swipes, and Mary didn't know how they got there. Jane also received a call from the police asking her to pick up her mother after they found her stopped at a light in town, and that light had changed several times. When the police talked to her, she was not aware where she was. Mary's house is 85 degrees in the summertime because the air conditioner needs to be fixed. But Mary also recently received a utility shutoff notice for non-payment, even though she has $50,000 in her bank account. Neighbors are concerned about Mary because she likes to do her yard work in her bathrobe. And Jane stated that Mary keeps a clean house, is good about hygiene, and takes her daily medications. She uses a bi-weekly dispenser. Mary is still a great cook and loves to play games with her grandchildren. Mary has good days and bad days. And recently she had a bad day while she had an appointment with her doctor. And that doctor has concerns and recently recommended that she should seek guardianship to Jane. Okay, so the American Bar Association has developed a practical tool which aims to help lawyers identify and implement decision-making options for people with disabilities that are less restrictive than guardianship. Practical is an acronym for 9 steps for lawyers to identify these options. Now, the ABA intended this tool to blend in naturally with the case interview process, but in my experience, I just try to keep those various considerations in my mind while the interview proceeds naturally. It's a much more effective way of using it. The first letter in practical is P, which stands for presume guardianship is not necessary. What the acronym is trying to get you to do is consider less restrictive options like financial and healthcare power of attorney, advanced directives, trusts, and other supported decision-making tools. R is for reason. Clearly identify the reasons for concern. In our case, Mary has a problem. She's not paying her utility bills despite money in the bank, but we have options. There's automatic bill pay, online bill paying service, which gives a third party such as our client Jane access, and it appears that if Mary has the capacity, she can execute a durable power of attorney to help with financial matters. Another set of reasons for concern is that mom is taking medications, but she's taking them on a regular basis and she has good hygiene. However, when she went to the doctor on her own, the doctor was expressing concerns about her medical capacity. And while Mary's behavior is eccentric, bordering on inappropriate in the eyes of neighbors, it has not yet progressed to a point where we have to have serious concern. Also, another reason to look for concern is that she's still a good cook and keeps a clean house and engages with her grandkids, but she's got the house at 85 degrees in the summer. And she's even saying she has good days and bad days, which might be cause for concern and possible need of a home health aide. Additionally, mother may need the car keys taken away. We have unexplained damage to the auto, and the police incident is extremely disconcerting. So A is for ask. Ask if the triggering concern may be caused by temporary or reversible conditions. Those conditions could be like head trauma. Initially, you're unable to handle your affairs, but you might recover from that. Or drug or alcohol abuse, where you're addicted to such a point that you can't handle your affairs, but if you get sober and straight, then you can. Unfortunately, with dementia, as is the case here, it's not temporary, it's not reversible. It's progressive. Dementia does not have a cure, all right? You can only slow this condition down. But Mary has moments of lucidity, and during those time periods, she might be able to have the capacity to execute a power of attorney and a healthcare power of attorney. C is for community. You want to determine if the concerns can be addressed by connecting the individual to family or community resources and making some accommodations. So, okay, in this case, Mary seems to be doing fine at home with basic daily living activities. Our concerns stem from driving, money management, and somewhat eccentric gardening attire. Jane and her brother live in the same town and are likely available to help with transportation, bills, etc. as her condition progresses, because it will continue to progress. T is for team. Ask the person whether he or she already has developed a team to help make decisions. Are there friends, family members, or professionals available to help? Well, in our case, Jane and her brother are living right in town and appear engaged in mom's life. And you also want to find out if this person has appointed a surrogate to help make decisions. Well, in our case, mom has not yet done that, but based on the facts here, it is a distinct possibility at this point in Mary's life. I is for identify abilities. Identify areas of strengths and limitations in decision making. So you're trying to find out whether or not the individual can make decisions and explain their reasoning. Can they maintain consistent decisions and primary values over time? And here in our case, most of the time she can do this, but there are some serious concerns about driving and handling her finances. C is for challenges. This would be concern over supporters, risk of undue influence, risk of abuse, neglect, exploitation, disputes with family members. It's not really an issue in this case. The facts just don't present themselves to be that kind of consideration, so we don't really have to deal with that issue for Mary. A is appoint a legal supporter or surrogate consistent with the person's values and preferences. So that would be an agent under a power of attorney or a healthcare power of attorney, maybe a trustee in a living trust, or assign a representative payee for Social Security retirement benefits, or if Mary was a veteran, then a fiduciary for veterans benefits. Can any of these appointments meet Mary's needs? That's the question we're trying to ask and answer right now. Finally, L is limit. Limit any guardianship petition and order if it's needed. You're trying to shape the order to preserve that person, Mary's, rights and goals if it's necessary. And you're going to periodically reassess for modification or restoration of those rights if you have to go that far. It's my opinion in this case that it's not ripe for a guardianship petition. There are plenty of supports available to Mary to have her live an independent, healthy life at home at this point in time.